Hearing the appeal Guyah against Commissioner of Customs on another.
Yes, do sit down, everybody. Apart from Captain Bezic, who I imagine wants to open his appeal.
Good morning, my lady, my lord.
Good morning.
My lady, my lords, Mr. Guyah, represented by myself, with me, my co-counsels, Ms. Terry Ann Guyah and Mrs. Angel Bezic-Reed. The presentations will be done by myself and Ms. Guyah. There are 4 issues before your board, and I intend to deal with issues A and B. Issue C will be dealt with by Ms. Guyah, and I will return, if you'll allow me, and I will deal with issue D. With us also, assisting us, is Mr. Christopher Dunkley, also of the Jamaican Bar. My lady, my lords, I want to start by dealing with some assertions, very briefly, that were made in the respondent's case, that the appellant had raised new issues. These issues can be found at page 415 of the electronic bundle, in paragraphs 18, 19, and 20.
Yes.
And the first one in paragraph 18 raises the question of whether the motor vehicle was properly seized and asserts that that was never raised by the appellant before Justice Pusey in the first hearing, in the hearing of the fixed date claim form in the Supreme Court of Jamaica. And we say in response to that, my lady, my lords, that the issue of seizure was never in contention before Justice Pusey, and in fact was never a point that needed to be argued in the Supreme Court, as the learned judge had determined that the Commissioner's power in this regard was unfettered. This point, however, was raised and fully ventilated in the Court of Appeal. The assessment of the validity of the seizure.
What seizure are we talking about?
We are talking about the seizure of the Suzuki Swift motor car.
I know, but which? Because your claim was based on the assertion that the car had been forfeited, and then various other events had happened.
It was, and then it was, the forfeiture was restored by the Commissioner, we say.
Yeah, and so are you talking about the second seizure or the first?
Yes, we're talking about the seizure by the customs agents of the vehicle from a third party into whose care it had been given.
From the sister?
That's correct. That's correct, my lord.
So that's the one you're talking about?
That's the one you're talking about?
That's the one we're talking about.
Okay.
Thank you.
This was 2012,
Indeed, yeah.
as opposed to the 2010.
And I believe the date might have been actually the 12th of February.
Something like that.
Or the
yes.
9th of February.
Yes.
We have a document
But
relating.
not the prior event, which started
Not the
the
prior
whole ball
event, not
rolling.
the customs seizure
Yeah.
on the wharf. No, Melody. Ironically, this was seized at the law school in Jamaica. As you say, the point was raised and fully ventilated.
What is your point about the 2012 seizure? We have a document relating to it. Are you saying it was valid or it wasn't valid?
Oh, no, we're saying the 2012 seizure was definitely invalid, that there was no authority in law for that seizure.
As I understand it, what you're dealing with now is the attorney's submission that the complaint that the second seizure was bad is a new one.
It's a new one. That is what I'm dealing with now. There are 3 issues that they raised. This is the first one. And their contention is that these are new issues before the board, my lord.
Right.
So I continue. I say that it was raised and ventilated in the Court of Appeal, and the assessment of the validity of that seizure was raised before the panel by the appellant as being one of its first contentions in response.
Yeah, but if you're raising, if you're as it were addressing, as I think you said you were, paragraph 18 on page 415.
Correct, my lord.
That looks as if it's about the first seizure,
Well, that's why I was asking.
because it says the appellant's own evidence was that he had seized the 14 vehicles of which the Suzuki was one. Now that's talking, isn't it, about sometime prior to January 2011.
That is correct, my lord.
So you may be setting up the wrong Aunt Sally. Sorry, the wrong target.
I think Your Lordship could be right. I'm sorry. I think Your Lordship is correct. I think Your Lordship is absolutely correct.
Well, that's why I asked the question. Because the paragraph 18 is obviously dealing with the
With the
very first event that set the whole ball rolling.
Yes, the very first event.
Seizure on the docks.
And what we are saying, however, is that you're quite correct, and I stand corrected. Please forgive me. What we are saying, however, is that the issue was ventilated entirely in full before the Court of Appeal. And that, in fact, led to a discussion into Section 215 and the requirements for notice in that section. The respondent, who was represented by Ms. Althea Jarrett, replied to the arguments of the appellant in the court below, that is to say, the Court of Appeal, my lady, my lords. And the assertion made by her was that Section 215 would have remained applicable as the goods would have been deemed condemned. It remained an assertion of the appellant that the notice of seizure, not being served in accordance with Section 215 of the Customs Act, signified that the goods were never properly seized, and as such was not relied on by the Commissioner of Customs in preparing his response to KLC, and by KLC I mean Kingston Logistics Centre, the wharfinger's application under Section 91, and was therefore not referred to by the wharfinger in its own application to the Commissioner of Customs. The statement by the respondent about the fanciful assertion refers to the argument that the possession of the goods by KLC would have deemed Section 215 application would have deemed Section 250 applicable, as the notice would have been required, is, in our opinion, wholly incorrect, a point which will be dealt with further in our submissions. The second issue is in paragraph 19, the forfeiture of the goods being premature. It is asserted by the appellant in the lower court that the administrative forfeiture done by the Commissioner of Customs was indeed premature, as the seizure was never effected. Justice Sinclair Haynes, sitting at the hearing of this matter in the Court of Appeal, sought further clarity on this point, raised by the appellant that notice not having been served would render the seizure a nullity. The respondent was present through his counsel, Ms. Jarrett, entirely throughout this discourse in the court below. Finally, at paragraph 20, there was a failure by Customs to serve the notice of seizure on Kingston Logistics, and this failure caused the Commissioner to grant KLC's Section 91 application. We would simply reply by asking this board to consider that if indeed we are arguing that the forfeiture took place pursuant to an invalid seizure, it follows that we are entitled to assert, in the absence of clear evidence of service, that there was no service. So these are not new contentions unsupported by evidence or not having been raised in the court below, one or other of the courts below.
But I mean, I not quite understand. The 2010 seizure was by your client and was asserted by him in his affidavit to be a valid seizure. Yes?
In paragraph 11 of his affidavit,
yes,
he said that he said very clearly that he seized it.
Are you now saying it was valid or invalid?
We are actually saying that irrespective of what Mr. Guyah said, seizure is a legal event. It is not a statement.
No, but are you saying it was invalid or valid?
It was never valid.
But how can you do that?
It was never effective.
And you're saying it's ineffective because of the act. Wait a minute. Because of the absence of notice to KLC?
Notice.
Is there any other reason?
No, my lord. Not that I can immediately come to mind.
Thank you.
Absence, by the way, of a seizure notice.
Can you, what provision do you say that seizure was made under? I mean, what was he purporting to make that seizure under? What provision of the Act?
What provision of the Customs Act?
Yeah.
That would have been Section 215, I believe.
I don't think so. In Section 215, we may need to look at these, but it seems to me that the section that, I mean, why don't we have any documentation about that seizure? Because there must be some documentation saying what it was done under.
The documentation that we have, my lord, is all that the appellant was able to muster from his own resources.
So he
The
must
Crown,
know.
the Crown provided nothing.
But what does he say what power does he think he was exercising?
I believe he thinks he was exercising the power under Section 215.
Well, 215 has to do with procedure following on a seizure. It doesn't provide any ground for seizure itself.
Well, the early part of 215 deals with the requirement for notice.
But where do we find 215?
Yes, but that's, once you seize something, you have to give notice to the owner, basically.
Well, effectively, what we are saying is that without the notice, it is not in fact seized. Because otherwise, the wharfinger would not know that there had been a seizure. Customs has access to all of the ports, all of the warehouses on the ports, including the bonded ports held by the wharfingers.
The provisions in the Act which authorise seizure come much earlier in the Act than that, and form part of the Act dealing with
Section 88.
Essentially importation. Yeah, well, yes, 88 is one of them.
Section 88 is one of them.
Now, Section 88 envisages a procedure where if goods are deposited under the control of a commissioner in a Queen's warehouse, and they're not, in terms of the section, they're not entered for warehousing or delivery within 3 months, then the commissioner is authorised to sell them and apply the proceeds, first of all, in discharge of the duties payable, and then any expenses incurred, and then the balance is remitted to the owner of the goods.
Significantly, I believe it does say that once the conditions of seizure and that the goods must be removed to a Queen's warehouse. Forthwith, I think.
Well, that part of the Act doesn't envisage forfeiture or seizure, for that matter, simply because customs duties haven't been paid. It envisages a procedure whereby the goods are put under the control of a commissioner. If the duties aren't paid, then he can sell them in order to recover the duties. But the forfeiture provisions are triggered if there's a breach of the sections concerned with maintaining the commissioner's control. If, for example, they're removed without his permission from
that is correct.
Then they're forfeited.
Contraband also can be forfeited.
Yes, exactly.
Yes, goods which are on prohibited lists.
Yes.
Issued by the minister.
So quite, and I'm wondering if there was actually a proper basis for forfeiture under those provisions, and if there was, it would be useful to know what it was.
Your Lordship might remember that the KLC and the Commission accepted this position was that the importers of those goods had abandoned them because KLC said, we'll give notice to them and they have taken no steps to clear the goods.
Yes.
So it was in those circumstances that the goods were seized by customs.
Well, there is a provision somewhere about derelict goods. I'm not sure if that would apply, or I mean, how it is. I mean, there must be some provision which, if there is a power, if there is forfeiture, if abandoned goods are forfeit, then there must be some provision to that effect in the legislation.
Well, the Commissioner does have a power to restore seizures, to annul seizures.
Yeah, but before we get to restoration,
yes, my Lord.
What about the original taking of possession, which was clearly done sometime before January 2011?
Yeah.
What power was being exercised?
By customs.
Well, by Mr. Guyah, acting on behalf of the customs. That's what he says he did.
But part of my answer to your Lordship is that, in fact, customs never took possession. And, in fact, we will rely on that point, in conjunction with Section 88.
But, look, he says that he he did, and that he generated an order for forfeiture. Now, and what power, that's right, isn't it?
I'm sorry, my lord?
He says that
Yes.
he generated an order of forfeiture.
Well, he seized it, and the commissioner, I think, issued orders of forfeiture.
All right,
Yes.
okay, right.
In his hand.
Yep, now then, what power was being
This is
exercised?
page 12 of the record, his affidavit at paragraph 11,
Yep,
where he says the commissioner had issued forfeiture orders and I had seized these vehicles.
he says he'd seized them for breaches under the Customs Act.
So he presumably knew what powers he was exercising.
Section 40 is concerned with delays. It provides, in a case where imported goods haven't been entered within the proper period, then it provides for them to be removed and kept in the custody of a commissioner in a Queen's warehouse, which is a defined expression. And if after that, if they're not cleared by the importer within 3 months, the commissioners may sell them. That's Section 40, Section 40,
Although he did not say
subsection
that
3.
explicitly in his affidavit, I believe your lordship has in fact defined correctly the power he was exercising. But he did not say it in his affidavit.
Well, if he was exercising powers under Section 40, there's no provision there for forfeiture. But what there is, or indeed for seizure, but what it provides for is the proper officer causing the goods to be deposited in
Sorry,
the
which
Queen's...
section are we on now?
Section 40
Of the Customs Act,
of the Customs Act.
which we have.
Oh, I'm beg your pardon. Beg your pardon.
Yes.
I've brought the British Act with me as well, and I'm looking at the British one.
I think you're thinking about section 70.
It's 77, 76 or 77?
Well, it's 78, isn't it? If any goods shall be unloaded, removed, or dealt with, contrary to the provisions of section 76 or 77, or to the terms and conditions contained in any written permission given by the Commissioner, they shall be forfeited.
Yes, but and 76 and 77 deal with how the Commissioner takes control of the goods and then ensures payment.
It's about unloading.
Yeah.
I'm sorry, I can't open it, and I can't.
So we have this terrible problem that your client's case, as I understand it, is that these goods, and specifically this one particular car, but actually there was more than
There
one.
are 14 of them.
Yes, were properly dealt with under the procedure in section 91. This is where they were uncollected and the poor old warehouse keeper is having to keep these wretched things in your warehouse and needs to get rid of them. Yes, that's what that's all
And
about.
indeed, my lady, every square foot of
Yes.
space on a port
Yes, and
is valuable.
your case is that they were properly dealt with under that, and it was all right for your client, in effect, to buy.
For anyone.
Yes, well, specifically your client,
Specifically,
who wasn't anyone. But one of the problems is that it's part of your case that they had previously been forfeited by the Commissioner.
it is part of our case.
Can't quite understand why it's part of your case, but it appears to be part of your case. And we're trying to puzzle out what on earth were the powers that your client thought he was exercising on behalf of the Commissioner when these vehicles were allegedly forfeit.
Yeah, I've found the Jamaican provisions.
But it is 76 to 78, isn't it?
It's section.
But he
I
never
think it's
explicitly
section. I think it's 87 and 88. 87 applies where goods either remain on board the ship or, having been unloaded, are not entered and produced for examination and customs clearance within 14 days from unloading. Then in that situation, the goods shall be deposited in such Queen's warehouse as the Commissioner shall direct. And 88 then provides for the, under subsection 2, for the sale of the
warehouse.
for the sale of the goods, if after a period of 3 months. and the recovery of the duties under subsection 3, and then the remittal of the balance to the owner. And if he can't be traced, then it goes into the consolidated fund.
It seems to me that we're not going to be able properly to deal with this appeal until we've got these provisions in front of us. Well, where did you get them from?
I just downloaded them.
I got them off Bailey.
But I mean, to what extent does this matter? I mean, your case is that whatever happened to them at this time, the process that then followed by which they were dealt with by the Wharfinger sought the consent from the commissioner was perfectly valid, and as a result they were validly sold. I mean, that's your case. So why does it matter for your purposes whether they were or not?
It does not in that sense.
But that was the basis of the Court of Appeal's decision, wasn't it? It was because they had been forfeited that they could not be restored on the authority of the commissioner. It needed the minister.
So argues the respondent.
Well, so did the Court of Appeal,
Yeah.
which is your problem.
And the respondent. Correct.
So we're faced with that.
Yes, my lord.
And that's why it matters.
Well, we need to look and see whether that's right or not, because your case is that the minister doesn't really come into it because the commissioner has the powers under Section 259.
If there hasn't been a forfeiture, then that may be so.
Well, but even if there has been a forfeiture,
And even if there has
maybe
been,
so.
yes, quite. But I mean, have you got the Act in front of you, all of it?
Yes, my lord.
Well, that's something.
But we can, I'm sure we can get from the library copies
do have
of
the entire.
the relevant sections, if we know what the relevant sections are.
That's what I'm trying to get at.
Yeah.
Yes.
But a part of my answer to your lordship
Well,
Lordship Cornwall, is that we set it out, or as I understand it, it was set out
these 2 pages.
as the history.
Is that in there?
This is what happened. The appellant could not have failed to disclose the fact that he had taken these steps. So it was set out. So it is not that we rely on it per se, but it was a part of the
No,
history.
but Captain Bennett, you forgive me. You've got to cope with the Court of Appeal's decision
Yes.
that
we'd better
because the thing had been forfeited, the various steps that were taken afterwards weren't lawful. Now, I know you say they were lawful even though it had been forfeited. But at the moment what we're on is whether it had ever properly been forfeited in the first place.
That is our first position.
You asserted that it had been.
We asserted, my lord, that a notice of forfeiture had been issued.
Quite right. Okay.
That notice of forfeiture must follow on the back of a notice of seizure. We contend that without evidence of that service of that notice of seizure, there could have been no valid seizure and therefore no forfeiture.
I understand that, but I think you need to grasp that we are also, some of us, worried whether there was a proper basis originally for forfeiture, as distinct from putting it in the warehouse to be sold.
Yes. This is obviously not something that we can resolve. It's most unsatisfactory. The parties should have drawn our attention to all the relevant bits of the legislation. The Crown, as much as the appellant, we propose to adjourn to try and get copies for all of us of the relevant bits of the legislation.
But let me stand and say that it must be the appellant's responsibility primarily. So I accept that.
It is indeed, yes. But we can't proceed with this appeal until we've got this sorted out and we at least know what we're talking about. So we will adjourn, hopefully for not very long, but don't leave the building.
Unless there's a fire alert. Thank you.
Now, we now have what may be the relevant sections of the Act.
My lady, my lords, I again apologize. And I want to say to you that I am responsible for this delay because the answer is in the bundle. And it can be found at paragraph 10 of Mr. Guyah's affidavit. It's page 12, I believe, of the electronic bundle. Yes? And that affidavit reads that when the request was made, and the request he's speaking of is the KLC request to clear the goods under Section 91. The Commissioner referred it to me for my review and recommendation, mainly because the vehicles were the subject of forfeiture proceedings under the Customs Act for breaches of Section 210. And Section 210 is settled immediately thereafter. So I think it is reasonably clear that from Mr. Guyah's perspective, that was the power he was exercising. And the reason
Section 210 is about penalties.
It's a catch-all section.
And it says that where someone's committed an offence, the goods shall be forfeited. But the basic proposition
Any
is
prohibited, restricted.
someone's committed an offence.
Yes.
We don't know who's alleged to have committed what offence.
The reason why 210 would have been applicable is because the importation of vehicles requires a license. That license was not produced. Therefore, that would have been a prohibited item without a license.
Sorry.
I'm sorry, I didn't understand that.
The importation of motor vehicles into Jamaica requires a license. That license was not produced, and hence a restricted item was being imported without a license. That would have been a breach.
Is that referred to anywhere in the evidence?
It's referred to in his paragraph where he said the forfeiture proceedings were in train under the Customs Act for breaches of Section 210.
Well, there must be some documentation. If forfeiture proceedings were in train, there must be some documentation.
Even if there isn't, I know you say that you can't produce the documents, but Mr. Guyah must know what he thought he was doing. Where does he say that he forfeited them because they'd come in as vehicles without a license?
He simply says that that there were breaches of Section 210. So I can only obtain from that he was
And
exercising a power
your
under
best
210.
guess is that that's what it was.
210. There's no other section referred to.
Yeah.
And as to the paucity, the lack of other documentation, that we can do nothing more about. What we had is what we had.
Now, wait a minute, where's the restricted? So the point is, it's restricted goods, is it?
Restricted.
Yeah.
Contrary to prohibition or restriction.
It is treated in much the same way, for example, as a firearm. Can't import one of those either without a license.
But does the forfeiture depend upon the proof of the commission of an offence and somebody being convicted thereof?
Or merely, I believe, just bringing in the item without the license would be a breach.
Well, it might be a breach, but does that necessarily lead to forfeiture unless there's a conviction for the offence?
Well, the final words of Section 210 seem to suggest that all goods in respect of which any such offence shall be committed shall be forfeited.
That is correct.
Yes, but it's
And that is
premised on
why
an
he
offence.
says,
It's on the offence.
Yeah.
I believe, I'm sorry.
It's there as part of the sentence, isn't it? Shall for each, 3 lines on the bottom, shall for each offence incur a penalty of not less than treble the import duties, etc., 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 and all goods forfeited.
Yes. And that is why I believe he says the forfeiture proceedings were on the way in relation to these goods because they had breached the restricted importation prohibition.
So who is being prosecuted?
Well, do you have to have a prosecution to get the penalty of triple the import duties, or can the Commissioner impose that as
Upon
as
whom?
it were, a civil penalty?
But on whom?
Well, quite.
I do
On the importer.
It
It's gotta be
would
someone-
have to be the
It's got to
importer.
be somebody.
I don't think they would have charged the wharfinger. It's just
No.
It would
conduit.
be the importer.
Well, it's either an importer or someone who knowingly harbours
No man knowingly
or
harbours
keeps or conceals.
is party to bringing them in deliberately without a license.
But so who was the guilty party in this case?
It could only have been the importers, I believe.
We don't know who the importer
But
was.
those very importers, if you recall, Kingston Logistics application indicated that they had given notice, and I suppose by that they mean as best as they could, to the importers who had just simply not responded.
No, but the point is that Mr. Guyah, in order to serve, or the Commissioner to serve these notices in 2010, must have thought that there was someone who was guilty of an offence and must have known who that person was.
Well, that's if he was acting correctly.
I cannot add anything.
Which is one of the questions in the case, unfortunately.
With your permission, I would embark on a discussion of issues A and B, which I believe can be conveniently discussed together.
We'd better get on to them, yes.
Thank you, Melanie.
And yes, indeed, they have to be discussed together.
Thank you. So the issues were worded by saying, did the Court of Appeal err in finding that the Suzuki Swift motor car was on custom goods? Did the Court of Appeal err in its interpretation of sections 210, 214, 215, 219, 259, and the 91 of the Customs Act? And we start by reminding your board that the respondents contend that the motor vehicle is on custom goods because the Commission of Customs revoked its forfeiture and disposed of the vehicle upon an application by Kingston Logistics Centre, which was in contravention of the customs laws. My lady and my lords, we recognize that it is correct that when goods are seized or subject to forfeiture and condemnation under the customs law, that goods, that are seized are subject to forfeiture and condemnation under the customs laws. We submit that in order to effect seizure of the goods, a process or a procedure must be followed. And this is, of course, pellucidly outlined in Section 215 of the Customs Act, which states inter alia that, and I'm quoting, whenever any seizure shall be made, unless in the possession of or in the presence of the offender, master or owner, it continues and then says, the seizing officer shall give notice in writing of such seizure and of the grounds thereof to the master or owner of the goods. And it goes on further to indicate the acceptable methods of service. In the absence of seizure being done, therefore, in actual presence of the master or owner, service of a notice is required under the Act. The respondent's contention that Kingston Logistics Centre was the owner of the vehicles for this purpose, by virtue of their possession of the vehicles,
by virtue of their possession?
By virtue of their possession. The respondent's contention is that KLC were the owner of the vehicles for this purpose, by virtue of their possession. Because they were clearly in KLC's possession, my lord.
Well, wait a minute. I just want to understand it. KLC were the owners for the purposes of Section 215 because they were in possession?
Because that is the respondent's assertion. And therefore, they will continue by arguing that because it was in their possession...
No, I don't think it's the respondent's assertion, but is it yours?
No, my lord. No, my lord. It's not.
No, well,
it's not. We say that's an ill-founded contention. KLC was the wharfinger and would be the de facto agent of the ship owner, master, or importer. Indeed, if one looks at their letter, they explicitly indicate that they are the agent. And of course, that's what a wharfinger is, the agent for a shipping line. In this case, I believe it was Zim, and the agent for the master.
So, I'm awfully sorry, I'm very slow, Captain Busy. Are you saying to us that the seizure failed to comply with Section 215?
That is correct, my lord.
What needed to be done under Section 215 to make it comply?
Clear evidence of service.
Service of whom?
On the owner.
But the owner was
the master.
Or the master. And you're saying KLC was the master, was the agent of the master?
KLC is the agent of the... Sorry, clear evidence of the ship owner or the owner. Yeah. KLC was the agent, was the wharfinger, and therefore the agent of the master.
Got it.
Yeah.
But there
if notice had been given to KLC, that would have been all right. But you say there's no evidence that notice was given to it.
And what we assert, and I am taking myself a little bit out of sequence here, is that seizure is not merely a statement. It's a legal event which has a process. And that process includes evidence of the service of the notice in this instance. I would like to explain this in a practical sense, my lady, my lords. So that, for example, where a customs officer is examining a shipment in the presence of the wharfinger for the purpose of clearing consolidated cargo and finds goods that are unmanifested or prohibited, the customs officer would take physical custody of these goods in the presence of the wharfinger, and no notice would be required. That is the presence seizure, or presence exception. Where, however, upon the goods being properly deposited in the wharfinger's possession, and customs then takes a decision to seize these goods for whatever reason, they would attend, or would be expected to attend upon the wharfinger, serve them the notice of seizure, and then physically take custody of the goods and remove them to a Queen's warehouse pursuant to Section 214 and, of course, Section 88. The wharfinger, KLC, then would not know about the Commissioner of Customs' decision to seize the goods unless a notice is presented to him, ordering him to release these goods into the custody, care, and control of Customs. If no notice was required, as our learned friends are contending, then Customs could enter the wharf and seize the goods, or any goods, without any reference to the wharfinger. A moment, please. And the wharfinger would have no way of knowing whether the decision was genuine and the basis for such a decision, so as to put himself, the wharfinger, in a position to account to his client. Those clients include the importer and the master, in respect of which freight and handling charges would already have been incurred, or indeed to make the objection referred to under Section 215, which the time in respect of which begins to run from the date of service of the notice. We say that this would lead to serious risks of fraud, liability, and non-transparency, and we respectfully suggest that it could not have been the intention of the legislators to give this kind of untrammeled power to Customs to seize in secret, and for Customs to seize at will without notice to a wharfinger. The notice referred to in Section 215 is in fact a notice of seizure, a document which, apart from the heading which replaces the word detention with the word seizure, is exactly the same as the notice of seizure which is in your bundle, in the electronic bundle, at page 26. It contains the details of the goods and other relevant information. But in the first place, it's a notice of seizure, and then it becomes afterwards, I wouldn't say morphs, but it's replaced by the notice, the actual notice of the notice of detention, is replaced by a notice of seizure.
Page.
I'm sorry, Miller?
Page.
Page 26 of the bundle, of the electronic bundle.
That's the notice of
Oh, well, that's the,
detention in respect
that's
to
the much
second.
later one.
Yes.
That's the following year.
The appellant, of course, does not deny that the notices of seizure were prepared as an administrative function by the Customs Department, as indeed is the norm when goods are left on the ports for failure to pay the required duties or for any other breach of the Customs Act. Furthermore, the Commissioner's power to commence proceedings for forfeiture has never been denied and obviously still exists. But there is no actual evidence before the court, or before this board anyway, to prove the conclusion of that process. The evidence before the board demonstrates that the vehicles were never in fact seized. The application by Kingston Logistics Center referenced as OG4 in the affidavit of Mr. Omar Guyah, and that is pages 31 to 32 of the electronic bundle, refers to the vehicles being abandoned as the basis of their application to the Commissioner of Customs under Section 91 of the Customs Act. Notably, this took place after the preparation of the notices of seizure. Section 215 of the Customs Act was not relied on by the Commissioner in preparing his response to KLC's application. Furthermore, the undisputed evidence that the vehicles remained in the possession of KLC wholly supports the point by the appellant that the notice of seizure was never served and therefore never enforced, as if indeed seizure was effected, then the vehicles would have been removed from KLC's custody and placed in a Queen's warehouse in accordance with Section 214 of the Customs Act. And that states, inter alia, that the goods together with all animals and things so seized shall forthwith be delivered to the care of the Commissioner. If it had been actually seized and such seizure duly enforced, as the respondents contend, then we say the goods would have had to have been delivered into the care of the Commissioner at a Queen's warehouse. Indeed, we believe that this explains why the Commissioner had to indicate, as he did, that the goods had to have been treated as if auctioned at the Queen's warehouse, because, firstly, the Commissioner would have known that the vehicles were not, in fact, in the Customs warehouse or Queen's warehouse. And secondly, and he said this, that the only way to facilitate the vehicles being entered and receiving the adequate documentation capable of effecting registration of the vehicles outside of a formal customs entry would have been to have been through an auction at the Queen's warehouse. Therefore, we say, the respondents' contention that the goods were always in possession of the Kingston Logistics Centre, contrary to their conclusion that this possession served to dispense with Section 215, Section 215's requirement for notice, in fact, wholly supports the appellant's assertion that seizure was never effected and played no part in the deliberations and decisions of the Commissioner of Customs to enter the goods. We also assert that Customs cannot administratively seize and enforce a seizure of goods from behind a desk, and in the absence of any evidence before the board from the Jamaica Customs Department to contradict this, we maintain that seizure was actually not effected where there is no evidence of notice of service of the notice, pardon me. The ministerial directions as set out in sections 216 in relation to disposal of the goods do not, we contend, apply in this case. Moreover, there is no evidence before the board that the minister, whether by general or specific directions, did not in fact approve the process as directed by the Commissioner of Customs. And we submit that the Court of Appeal ought not to have assumed that approval does not exist in the absence of evidence to that effect. What the respondent in fact is arguing in that vein would effectively invert the normal rules of evidence. They have asserted that an event did not take place. They then completely eschew the requirement for them to provide evidence of that event not taking place, and throw this in turn on the appellant. That evidence, of course, would have been clearly obtained from either the minister himself or the Commissioner of Customs. I'm talking about evidence that these directives, which the Commissioner had issued in 210, were not approved by the minister. My lady, my lords, even if the goods are in fact found to be seized, we contend that the Commissioner is endowed with the power to reverse any seizure pursuant to Section 219 of the Customs Act and allow the entry of any goods in such way and manner as he deems fit pursuant to Section 259 of the Customs Act. The discretion of the Commissioner of Customs to restore seized goods as he deemed fit was seen in the case of, and I have to say, my lady, my lords, I am deeply grateful that one of the names here, the apparent German one, is not the name of any member of this panel or any judge that I'm aware of, because I have not yet figured out how to pronounce it, but I believe it is Allgemeine Gold und Silberschleider Stadt against Customs and Excise Commissioners, which is at tab 3 of the joint bundle of authorities. The respondent's contention that there was no requirement for ministerial approval in that case, thereby making the case inapplicable, is, we submit, a grasping at straws. A Commissioner of Customs is given wide powers as outlined in the Act and would not be subject to ministerial directives unless seizure had in fact been effected. And a moment, please. We continue by saying the Commissioner of Customs in fact went further to issue procedural directives concerning the entry of these vehicles, which is exhibited by the appellant in the affidavit at OG 6, page 37 of the electronic bundle, and which were relied on by all parties, including the appellant. Of note is that the Commissioner directed that the goods were to be treated as Queen's Warehouse auction goods in the absence of a formal customs entry, which would normally have resided with the importer. It would have been the importer's place to make that entry normally. This, we submit, is not unusual, as the public auction process is the only mechanism for goods to be entered without the formal customs entry, and in the case of motor vehicles, would have been the only avenue outside of a formal entry.
But in this case, there was no auction.
I'm sorry, my lord.
But in this case, there was no auction.
It was.
There was no auction.
There was no auction. There was no auction.
No.
Oh, it was treated. It was so treated. Yes. Is that? I'm sorry if that. I didn't understand what your lordship was saying.
Yeah.
There was no actual auction, my lord.
Yeah.
It was to be. He directed the goods should be treated as if there was an auction, because that would generate the paperwork which would allow the vehicles to be entered into the revenue system.
And who did that?
That would have been done administratively.
No,
by customs.
not would have been. Who actually did it?
The Commissioner's office, a department.
Mr. Guyah.
No.
Well, how do you say that?
There are many branches in customs.
Well, of course there are.
Assessment branch, valuation branch.
Yes.
There is a supervisor branch that checks documents.
Right.
These vehicles would have had to pass, the documentation would have had to pass through all those processes. So,
Now you're giving the evidence. But then I did ask the question.
Now,
at page 34,
I asked the question because your submission had been that an auction was the only means whereby these goods could be...
other than a formal entry.
Yes, other than a formal entry. And if that's so, the provisions must be referring to a real auction rather than a fictitious auction.
All I can say is that the Commissioner made that directive because, and he explained why. He explained that this was the only way. In fact, at page 34 of the electronic bundle, it stated, given the difficulty with the lack of proper documentation to adequately prepare an import entry, C87, the clearance process would have to be treated as an auctioned vehicle.
That seems to mean that it would have to be auctioned, doesn't it?
I cannot.
It's saying.
I can say another year.
It's saying we haven't got any proper documents, so we shall have to auction it.
It is saying it has to be treated as one.
No.
I can't go further than that, madam.
All right.
I wouldn't wish to try to take you there.
It might be said it's ambiguous and that it could mean either that it requires an auction or that it should be treated as if there had been an auction.
But I want to be careful that I don't again fall into that error of attempting to give evidence. But I don't think that there's any evidence in any of the documents which shows that Mr. Guyah was actually involved in that process of preparing the import entry, sorry, not the import entry, the Queen's Warehouse documentation, which would normally follow from an auction.
All right.
I'm reminded that at page 37, the process is actually explained in some detail. And this is from the collector of Kingston and Montego Bay to the Deputy Commissioner of Customs.
Yeah.
Sorry, from the Commissioner himself, pardon me.
So it's a valuation rather than an auction.
Correct. And I did make the point to you, and I knew instinctively that somewhere it's referred to that there are these various branches. There's a valuation branch.
Sorry, can I just understand what you're referring to on page 37?
That's a memorandum from the Commissioner.
Yes, I know, I see that. But it talks about, in the third paragraph, where the goods require permits, which the wharfinger would not be in possession of, then goods would be treated as Queen's Warehouse auction goods.
Yes.
And all duty payments done from there, providing what other commissioner met. So that's obviously what his directive is referring to. But what the term Queen's Warehouse auction goods, where does one find that explained in the Act?
There are numerous references in the Act to the Queen's Warehouse, which really means a customs warehouse.
Is this, this is section 88, is it?
Yes. If you look at the fourth paragraph in OG 6, I think that is page 37 again. The fifth paragraph, pardon me.
It's the fifth
Yeah, it's
paragraph.
the
The fifth paragraph, yes.
Because that's the way you get it registered in Jamaica.
That is correct.
Exactly.
This is the fifth paragraph from the
Yeah.
memorandum.
And it provides, in summary, for valuation rather than auction, doesn't it?
That effectively was the replacement process which the Commissioner authorized. Continuing, if you permit me. We note that the respondent contends that KLC was not the ship owner or master or agent of either, and therefore were not entitled to make the Section 91 application. Our answer in this is that agent is defined in Section 2 of the Customs Act, and that is tab 1 of the Joint Bundle of Authorities, page 438 of your electronics bundle. And that includes, quote, any person who notifies the Commissioner in writing that he intends to act as the agent, and on whose behalf any person authorized by him signs any document required or permitted by the customs laws to be signed as agent.
Sorry,
Therefore, the Wharfinger KLC...
Forgive me, which definition are you reading?
The definition of agency at page 438 of the electronic bundle.
Yes, thank you.
That's Section 2 of the Customs Act, my lord.
Yeah.
Agent, yes.
So, yes, but of course, if you're an agent, you've got to be an agent of somebody, haven't you?
My lord.
If you're in order to be an agent, you've got to be an agent of somebody.
Of someone, yes.
And this is about agent of the master of the ship.
Or the ship owner, because KLC asserted themselves to the Commissioner as the agent of the master.
Did they?
In their letter, indeed.
Well, they actually said, I think, that we're the agents of the goods. Let's have a look at it.
Yes. Yes, it's page 31. They begin by describing themselves as acting as Wharfinger's oblique agents for the following consignments, and they list them. And then they say the importers have been duly notified, have not effected any clearance, nor have they entered into any arrangements with us indicating any intention to clear them. We ask your due consideration in allowing us permission to enter these goods as belonging to us, Kingston Logistics Centre, as we believe that we have met all the requirements specified in the Customs Act. And that seems to be a letter written entirely on their own behalf.
On, my lord?
On their own behalf, rather than as anybody's agent.
Kingston Logistics Centre asking us Wharfinger / agents for the following consignment. We would assert, my lords, that as agent for the consignment, a consignment is an inanimate entity, which has an owner.
They could equally have said, they could have said quite accurately, we've imported these vehicles as agents on behalf of the importers, or we've been storing these as their agents. But the point is that in the last paragraph of the letter, which is the paragraph where they're actually asking for something to be done, the only person with any interest in it being done, according to the letter, is them.
Where they say, as the importers have been duly notified.
Mm-hmm.
To us.
Not 91 at all, was it?
We ask your due consideration in allowing us to enter these goods as belonging to us.
Yeah, that's the important sentence.
Yes, ma'am. But I think that is enough of an assertion that gives them the authority to make this application.
Sorry, it gives them the authority as what?
As
somebody's agent?
The virtual owners of the goods at that point in time.
Well, you can't have it both ways, Captain Basic. Are they the owners of the goods, or are they the agents of somebody who
In fact, every Wharfinger is an agent of the master. Every Wharfinger must necessarily be an agent of the master.
Yes, that's true. but it rather looks from the last sentence as though they weren't writing this letter on behalf of the master. They were writing it for their own benefit. as principals.
Perhaps, my lord, that is one possible interpretation. I can only say that these letters, of course, are written in a business context in which one would have to expect that the wharfinger, in his normal capacity as agent for the ship owner or for the master, always writes in that capacity. Sorry?
Well, you can say that right at the beginning of the letter, they say they're acting as wharfingers stroke agents for the following consignments. That's what they say at the beginning. And so that's what they're claiming. They'll be able to make the request under Section 91. But then at the end they say, we want you to treat them as ours.
And I want to remind your ladyship that, in fact, they had a proverbial axe to grind, because by that time they were owed money for the storage.
Well, definitely they'd had these things for a long time, and they wanted to get rid of them.
A long time.
Isn't the whole basis of the procedure at page 37 that the application is being made by the wharfinger?
Yes.
And I thought that Mr. Guyah's position at page 13 was, although that's not strictly within Section 91, which is purports to be, it's in effect a modification of that done under Section 259 to deal with a particular problem which isn't conveniently covered by the Act. I mean, that,
yes,
as I understood what he was saying, and that seemed to make some sense, because you've got a real problem with the wharfinger stuck with these goods. Someone's got to do something about it.
Over 2 years.
The Commissioner establishes a procedure whereby the wharfinger can make an application, and they're then treated as Queen's Warehouse auction goods. And that's what I understood was being said. I mean, it's difficult to find it, but I think at the root of it, that's what it is.
And it must be remembered also, again, I told you in the disjuncture, that the procedures established by the Commissioner, albeit that they had to be modified to deal with motor vehicles specifically, were established in 2010. They weren't established for this vehicle, for this Suzuki Swift, or for these 14
I mean, there's no challenge to the memo, the procedure set out in the memo of 2010. That was obviously dealing with a particular problem, and whether it was appropriate for it to be used for this case is another matter.
Settled policy.
So, it would be, therefore, our contention, pardon me. We say that the wharfinger, KLC, had asserted their right to the Commissioner in that letter of January 31st, 2011, page 31 of the electronic bundle, and they were in possession of the goods as a proper agent under the law, and we therefore submit that it was lawful for the Commissioner of Customs to have granted KLC's application under Section 91 of the Act. I also pause here to make this short point, that I believe that an argument about whether KLC had the right to make an application leads us to barren territory, because it is the Commissioner who ultimately must decide whether an applicant is merited at all to make an application. And so having decided, I believe the discussion should not in fact go any further. At the completion of the clearance process.
Forgive me, Section 91 is limited in that the application has to be made by the ship owner or the master or the agent of either. Yeah.
But what we say is that it is clear that the Commissioner must have decided that KLC fell into one of those categories, ship owner, master, or agent of either. And we say that a wharfinger, by definition, must be an agent of the master.
Well, no, what I thought was being said was it didn't strictly fit it, but by Section 259, the Commissioner was able to adapt it so it did fit this situation. Yes. That I thought was the point.
Yeah, and he's done it via the memorandum on page 37.
Exactly.
So at the completion of that clearance process, which came to an end, we politely assert, when the wharfinger or agent complied with all of the procedural directives of the Commissioner of Customs, Kingston Logistics Centre, now being the owner of the vehicles, all the vehicles, were at liberty to sell to whomever they wished. The appellant, being an agent of the Customs Department and a public servant, could not be excluded by virtue of his employment. The fact that the appellant obtained one of the 14 vehicles cannot, we say, warrant him being singled out.
He said, I think, that he...
All 14 vehicles were sold. That is not in dispute.
He said, I think, that he had at least 5 of them, didn't he?
I'm sorry, Mr.
Didn't he say that he had more than one?
There was a question and answer by Audrey Carter in which she asserted that there were more than one vehicles which were connected to Mr. Guyah. That has never been stated by Mr. Guyah in the first place. And in the second place, the authorities never took proceedings against Mr. Guyah in respect of anything but that single Suzuki Swift motor vehicle. That is all I can indicate in that regard.
Thank you.
In fact, as you will see later on, that very point that your Lordship raises was obviously very attractive to Justice Brooks when he wrote his judgment. In the circumstances, therefore, we submit that once the full duties and taxes were paid, which is not in dispute, and the procedures outlined by the Commissioner of Customs are adhered to, then the Suzuki Swift motor car could not have been deemed to be on custom goods. We therefore invite the Board to reject any claim by the respondent that in the course of action in this case, that this course of action in this case was marked by irregularities, malfeasance on the part of any person, or breaches of the customs laws committed by their own agent, the Commissioner. Absent an order of the court in any event in judicial review proceedings, it is our submission that the Commissioner's decisions, are binding on the Crown, whether these decisions were made in error or not. The dictum of Lord Denning in Robertson against the Minister of Pensions, that is at tab 6 of the Joint Bundle of Authorities, pages 500 to 501 of the electronic bundle, is instructive in determining that the Crown cannot escape the actions of its agents who give assurances which they intend to be binding and which are acted upon by the person to whom it was given, which is exactly the situation here. There were however many people who purchased these 14 vehicles from Kingston Logistics Centre. Kingston Logistics Centre was of the view that they had the authority to sell them. They were of that view because the Commissioner wrote directives which allowed the entry of these vehicles in the manner he had dictated to solve a problem, a real problem on the wall.
Mr. Besic, it would have been Mr. Guyah who would have relied on the propriety of these statements, wouldn't it?
Would you repeat that?
Yes. You're speaking about Robertson and about reliance on the effect of statements intended to be binding and relied upon.
Yes, ma'am.
The reliance here would have been placed by Mr. Guyah himself.
Yes, that is correct.
Yes.
Also by Kingston.
Also by KLC. By KLC. It ends up in Mr. Guyah's problem today. But initially it would have been KLC who placed reliance on it. And any member, any person whatsoever who came to KLC and said, how much do you want for this car? And KLC said, whatever. And they paid them, would have been acting on the reliance of the Commissioner's promise that KLC had cleared the cars in a normal and transparent way. Remember, my lords, the Commissioner speaking about the entry of the vehicles into the system. That system requires a host of clearances. You will notice that that memo was directed in part to the Revenue Commissioner in Montego Bay. That was, we say, obviously to alert him that these vehicles would be entered into the system, because otherwise they couldn't.
But if there was any irregularity, Mr. Guyah, as the purchaser, would have been aware of it.
If there was any irregularity?
Any irregularity in this process of clearance, Mr. Guyah would have been aware of it.
I believe so. I believe so. And if your lordships want me to be as frank as I can be, I think Mr. Guyah or any other person in his position would have tried to avoid those irregularities patently appearing. I think so. I think that would be the normal response. But yes, I think it would have been picked up. It is the appellant's contention that it is presumed in law that the decisions of a public officer, and more so the head of a public body, as in the Commissioner of Customs, are legal and are illegal. And this presumption can only be displaced by evidence on facts, or facts which cannot be reconciled. Presumption of regularity was discussed at length in the case of Bagwadine against the Attorney General of Trinidad and Tobago. This is at tab 5 of the Joint Bundle of Authorities, in particular at pages 487 to 495 of the electronic bundle. The court found that the decider was entitled to the benefit of the presumption of regularity and was not obliged to adduce evidence that he took only the correct factors into account. This is an error which we submit that the Court of Appeal fell into because of their failure to accept that the appellant was to be afforded the right to rely on the benefit of that presumption. The appellant, of course, coming through Kingston Logistics Centre. The appellant further submits that he was entitled to rely on the decision of the Commissioner of Customs and should not be made to suffer as a result of the Court of Appeal's error. It must be brought to the Board's attention at pages 325 to 333 of the electronic bundle, where the appellant filed a claim for a stay of departmental disciplinary proceedings with a view to dismissal from the public service, which was brought against him by the government of Jamaica immediately after the criminal case was concluded in his favor. And that case was concluded largely due to prosecutorial misconduct, and if your lordships may be referred to the judgment of Her Honour Mrs. Wolfreys, as she then was, at pages 319 to 324 of the electronics bundle.
I'm sorry, pages?
319 to 324. The judgment of Her Honour Mrs. Wolfreys in the resident magistrates court, now called the parish courts.
Yes.
These proceedings were stayed, and that order of the Supreme Court can be found at pages 335 to 336 of the electronics bundle. And they were stayed during the currency of this appeal before your lordship's board, your ladyship and your lordship's board. Notwithstanding that the respondent's position that it is the then Commissioner of Customs and not the appellant who erred and or exceeded his authority under the Customs Act. So what we have is a situation where the criminal proceedings have been concluded. The Court of Appeal rules against the appellant, and proceedings are then commenced for disciplinary dismissal. Disciplinary proceedings are then commenced for dismissal of Mr. Guyah. Yeah. And the proceedings, and it's indicated in the documents, refer specifically to the importation of the 14 motor vehicles, of which the Suzuki Swift is only one, of course, the one which he allegedly purchased. That had to be the subject of a further proceeding to stay that hearing, at least until your ladyship and your lordship's board have decided this issue of uncustomed goods. We say that to decide otherwise would mean that all decisions of the Commissioner of Customs or any senior public officer or head of government department are open to review and that no decision can be relied upon. This would defy the foundation of trust in the head of any public body and would pose serious legal implications for rights that have accrued as a result of such reliance. And that is in fact the case of this appellant. The case of Commissioner of Customs and Excise against Tan and another at tab 7 of the Joint Bundle of Authorities, page 554 to 513 of the bundle, explains the point clearly. And here it says that where customs has determined the duties and taxes payable on the importation of goods, and these duties and taxes are paid in full, the customs process comes to an end, and there is and can be no liability to customs thereafter. The court also examined the level of mistrust which would arise in the system if goods were always liable to forfeiture despite third-party rights having been accrued. One of the laws specifically adverted to this point, that the goods having traveled some distance into third-party hands would still be open to seizure if customs were correct. The respondents seek to rely on Boddington against British Transport, and that is at tab 10 of the Joint Bundle of Authority, pages 571 to 595 of the electronic bundle. And this is to support their argument that the respondent can raise the illegality of the action as a defense. We submit in response that the case is not applicable to this case, as it concerns the ability of a private citizen. Boddington concerns the ability of a private citizen to mount a public law defense to an action. The court in that case grappled with the question of whether a man's liberty should be deprived on the basis that an order is a good order, when the court knows it would be set aside if proper proceedings were taken. As we therefore understand it, the rule of procedural exclusivity, which is raised in the response, and this was created in O'Reilly against Macman, on which the respondents rely, is that a remedy for a public law matter should be pursued only through the application for judicial review, whereas a private law matter should not be the subject of an application for that kind of review. The respondents have sought to rely on the case as, quote, a defendant in a civil case who seeks to defend himself by questioning the validity of a public law decision, and who, they contend, would be excluded from the procedural exclusivity principle. The case is not applicable to the respondent, as it is not their exclusion we say to rely on. The invalidity of the decision must arise as a collateral matter in a claim for infringement of private rights. Therefore, an aggrieved person can question the validity of the decision of a public official in his claim for infringement of his private rights, or he can use it as a defense to a civil action against him. In this case, it would have to be a defense raised by the appellant, as he is the one who is claiming infringement of his private rights. The respondents cannot call into question its own actions, and we submit that they have completely misinterpreted the law in this regard. The appellant further contends that the Commissioner of Customs did have the power to enter into the motor vehicles, to enter the motor vehicles in the manner he did. However, even if the court finds that the Commissioner did not have such a power, this error cannot be laid at the appellant's feet. The Crown and its agents must be bound by the decisions and the principles outlined in TAN, that the decisions of Customs is final and binding. Instructions of the Commissioner of Customs having been acted upon and the vehicle or vehicles having been cleared and duly entered meant that there was finality in the customs process, and its status could not legally be classified as on customs goods as defined by Section 2 of the Customs Act. Customs Section 2, I might remind your lady and your lordships, defines on customs goods not only as goods on which duty has not properly been paid, but goods which have not been subject to a proper customs process, effectively, or which have evaded the customs process. We say that that did not happen here. The Commissioner set out a process, and the goods went through that process.
But the result is that goods imported without a license, cars imported without a license, have been permitted to be driven on the roads of Jamaica.
If they are legally entered by a process approved by the Commissioner.
Mm-hmm. I mean, I don't know, but presumably the requirement for a license, one might imagine, has to do with ensuring that the cars meet Jamaican standards of safety and so forth.
Correct. In order to insure the car, you have to have it entered into the revenue system so that you can get what is called, well, we call it a license, a certificate of fitness and a license disc. In America, they call it a tag. I don't know what it's called in the UK.
Yeah.
But in order to get that, you have to go through, the entire formal process has to take place so that that party who is responsible for the Revenue Commissioner, and you saw the copy to him from the Commissioner of his process, of his instructions or his decisions, would be in a position to accept the vehicle and collect the license fees on it so that you could then go to the insurance company and license it so you can be compliant with the Motor Vehicle Third Party Risk Act and those kinds of things. We say further that Customs was not now at liberty to come and seize the vehicle outside of the customs area, a term which is defined in Section 2 of the Customs Act, especially in circumstances when the vehicle is in the hands of a third party. And we think that I will indicate that that will be more fully developed by Ms. Guyah.
If there is a statutory prohibition on the importation of unlicensed motor vehicles for road safety reasons, if there is a statutory prohibition, can the Commissioner bypass that or override it?
The Commissioner can only exercise powers given to him by the Act. Section 291 does give him that sort of power. And that power can only be curtailed by a ministerial directive. But we assert that when a commissioner, a head of a major government department such as a commissioner, exercises the power, in the absence of evidence to the contrary, there cannot be an assumption that he was curtailed. We also asked the board to bear this in mind. At the operative time in 2011, 2012, the procedures were already in place for 2 years. One would, I think, be fairly confident in expecting that a commissioner, by that time, would have known whether a minister was saying, no, I don't like your procedure, I'm not going to permit it. Or, fine, go ahead. He's, after all, a trusted public servant who must necessarily work with the Minister of Finance on a regular basis. Indeed, he's a servant.
It is.
Captain Bisick, do you say that Section 259 is wide, the power conferred by Section 259 is wide enough to permit the Commissioner to cause the entry and the customs processing of unlicensed vehicles?
We do say that. It is wide enough. Subject to a curtailment by the minister. But we stand firmly on this position that, again, when a public officer of that stature makes a decision on a statute.
But yes, Section 259 is premised on there being some lacuna. It applies to, the last few words, any case to which the customs laws may not be conveniently applicable. Now, is there any reason why the customs laws couldn't have been applied here?
Because the only other method of creating the documentation necessary to enter the vehicle into the revenue system would have been a customs entry, a C87, the form that he referred to, a massive form which has an abundance of details on which the car is assessed and valued and its engine capacity determined for there's actually a sliding scale, my lords, my lady, my lords. There's a sliding scale of duties based on engine capacity. The larger the engine, the higher percentage of duty paid on value, that sort of thing. All that would be done pursuant to a C87, which the importer would have to sign, or his agent, his customs broker, would prepare and sign for him. Absent that, the commissioner had to create something, a methodology, to have the cars entered. Now, if you auction a vehicle at the Queen's Warehouse, it joins the system formally. It rejoins the system formally because that documentation will automatically be prepared through the Queen's Warehouse.
Well, that's really my point. Sections 87 and 88 provide for real auctions.
Yes.
Unless there's some reason why that couldn't be done, can you fall back on Section 259?
But it does say it in any manner he considers convenient or fit.
Well, it doesn't.
I do not know how to go behind it, my lord.
Well, it says he can permit various things to meet the exigencies of any case to which the customs laws may not be conveniently applicable.
And initially...
Now, I'm wondering why, if you could have gone through a proper auction process as envisaged by Sections 87 and 88, how it can be said that the customs laws were not conveniently applicable.
I have two responses to that, my lord. The first is to remind your lordship what I think would be self-evident, that the same problem that the wharfinger has in terms of space, in terms of resources, is one which the Queen's Warehouses themselves would logically have as well. So that to go through a formal auction process would require not just that the vehicles be actually placed in custody of the Queen's Warehouse, thereby consuming space and resources, and security and all that sort of thing, but also require a process set out in the law which would take time for disposal of the vehicles. There was already a problem of 2 years in the case of some of the vehicles. That is one consideration. The second one, however, is the more general one, which I will state that I believe that while it is clear that the board or a court can say, we do not think the commissioner was right in a particular instance, initially it is for the commissioner himself to make the determination that the quote-unquote, well, the customs laws are not convenient in this situation. And that exigencies, and that is what was done. I could go no further than that, my lord. But I understand your concern and your question, and that is the best I can do to assist you with it. All of that, I point out, even if it is concluded that the Commissioner of Customs could have found a better method, that he could have auctioned it, none of that, we say, would defeat the rights of a third party who relies on the decisions of the Commissioner of Customs, bad though they may have been. Although we do not say that in the circumstances they were bad. He was trying to solve a 2-year problem. But we think that it wouldn't matter at the end of the day if even this board were to hold the view that the commissioner could have found a more palatable method of disposal, a more transparent method of disposal, I have no more words, a better way.
Whose rights are you talking about here? Are you talking about Ms. Carter's rights, or are you talking about your client's rights?
I'm talking about my client's rights derived from Kingston Logistics Centre.
But so you're saying that although the vehicle was sold to Ms. Carter and registered in her name, he was the beneficial owner of the vehicle?
Yes. And he was prosecuted for that purchase.
I'm not interested in that. I'm just interested in how you put the case. You say that he has rights as beneficial owner of the vehicle.
That's what he asserts.
Yeah.
You will see in the electronic bundle. I don't have it to hand, my lady, my lords, but perhaps my associate can assist me. But the copies of his credit card slips, which he used to pay Kingston Logistics, are exhibited to his affidavit. So, again, a decision could be made, a legal decision. No, you don't have any rights, even though you paid for it. But it is upon that basis that he founds his assertion that I am the equitable owner of the vehicle. Page 44, I understand, of the electronic bundle. 42, 44. Sorry, page 42 of the electronic bundle, I'm advised.
It's also the basis of the disciplinary action. The pending disciplinary action.
Yes, so one of those is for the duty and the other is for the balance of the price of the car.
That is correct, my lady. That is correct.
That's right.
And one can readily understand the assertion. Even if afterwards a court thinks that you are wrong, one, I think, can understand an assertion being made after spending, well, I know that the board may not understand. The board may very well understand. Our currency is vastly different from yours in value, so that one Jamaican...
Oh, yes, we do understand that.
$150 Jamaican. So we're talking about...
We have quite a lot of Jamaican cases, don't worry.
I shouldn't assume anything.
Now, we'd better make some progress, because admittedly, we had to break in order to make sure that we had all the relevant sections of the Act.
And I am in fact winding up my A&B at this point in
Yes.
time. I am really very close to completion. And I would simply say, therefore, that notwithstanding the appellant's contention that the Learned Court of Appeal, which is a court of review, and I made that point earlier, that in fact an original decision could only have been made by a court of judicial review. And that was not the manner in which this case traveled. The appellant sought a civil remedy of declaration. And we say that that court arrogated to itself the powers of a judicial review panel when it had no such power to make any original determination as to the correctness of the actions of the Commissioner of Customs. We say, therefore, respectfully, that notwithstanding that, we assert respectfully that the Court of Appeal erred, as even on that case, the Court of Appeal could not properly have concluded that the Commissioner was bereft of jurisdiction to make the directives which he did. and to take the steps which resulted in the clearance of the 14 motor vehicles. So that, expanding that, what I would say is that if it was that the Commissioner's actions were to be challenged on a jurisdictional basis, one would have to have determined that he had no jurisdiction to make those directives, or that the process in some way was so badly flawed that it could not be allowed to stand. One must remember, my lady and my lords, that in this process, the government and people of Jamaica got everything they were entitled to. The duty was paid. The clearance fees of the various parties, including the wharfinger, were paid. If there was a loss, that loss was to the importers who imported the cars in breach of the requirement to have a license in hand at the time when the car lands in the island. But there can be no assertion that Mr. Guyah's action or any one of the purchasers of the other 13 vehicles caused a loss.
Stole a march.
Or stole a march, caused a loss, did anything at all that left the public and the government penurious or out of pocket, that stole something from anyone. And I think, sadly, some of the considerations in this case are proceeded on that basis. My Lord, my Lord Hughes may quickly remind me of what he said before. I appeared in the criminal case, the RM court, which was eventually dismissed. At the beginning of that case, there was an assertion that the government had been robbed of $40 million in duty.
Well,
that assertion, it fell away.
That's not going to affect us.
But it fell away.
We've got these proceedings, and
You're quite right, ma'am.
got enough to contend within these proceedings without bringing.
But it fell away. I will say that. It fell away very quickly. So that is why I'm able to say now that there has been no, and can be no assertion of any loss to anyone. Nor, I think, can there be a valid assertion that these vehicles are dealt with outside of the customs laws. We say, finally, that the Court of Appeal also erred in its interpretation of the relevant sections of the Customs Act, which led it to the mistaken belief that the Commissioner did not have the powers which he exercised. I believe those powers existed, and they were properly exercised in the best interests of, well, certainly in the judgment of the Commissioner, in best interests of the country, and they resulted in the clearance of the vehicles, one of which was purchased by Mr. Guyah. It is clear, my lady and my lords, that the question of whether the goods are in customs is of tremendous importance to Mr. Guyah. Now, he facing disciplinary proceedings, which we have adverted you to, for that, because of that very issue. That is why that case has been stayed pending the decision of this board.
Yes, you told us that. Thank you.
That is, unless you have any further questions for me, all I can say.
Well, you have been bombarded, Captain Beswick, so...
That is your job, my lady. And
it
my
is.
lords, and it is also my job to accept that.
Can I just bombard you with one more question? On page 12, in the affidavit of Mr. Guyah, paragraph 11, this is talking about what happened back in 2010. The Commissioner, it said, had issued forfeiture orders.
What paragraph was you?
Paragraph 11.
Thank you, my lord. Yes.
The Commissioner had issued forfeiture orders
on his own hand,
as prescribed by the Customs Act. I had also seized these 14 vehicles. Now, are the forfeiture orders, by that does he mean the notices required by Section 215, or what, or is there some other provision that's being referred to?
One second. That is the forfeiture orders which would have been prepared pursuant to 210, my lords, I understand.
I see. So, I mean, there's no provision there for a forfeiture with some sort of notice to be served, unless we're going on.
You're looking at 210, my lord?
Yeah.
215.
And the 215.
Yes,
It is a very long section and sadly drafted in a very old style.
Yeah. I mean, 215 provides for a notice to be served on seizure,
Yes, my
and
lord.
then the goods are then automatically taken to be condemned after a month, unless they've been claimed.
Unless there's been a claim.
And if in the event of a claim, there's then a procedure gone through for forfeiture.
Yes, my lord. A condemnation procedure.
So my question is, what is Mr. Guyah talking about when he says the Commissioner had issued forfeiture orders?
Well, I believe what he's saying is that the Commissioner himself issues notices indicating that the goods have been forfeited.
I see. So this,
I believe, my lord, that Customs doesn't do anything unless that piece of paper is generated. Or that when anything is done in Customs, some document is
I
generated.
see. So it's a practice that's followed, but it's not actually.
It may not actually be in the law.
A statutory requirement.
But it's clear that they do this as a matter of course. And I would not be, I think it actually would be very reasonable for them to do this.
Yeah.
Do you happen to know, don't guess if you don't, whether forfeiture, strictly so-called, is accomplished in Jamaica by the Customs taking possession in a particular way and with the right statutory authority, or does forfeiture involve an order of a court?
I would say that 90% of forfeitures arise at the port of entry.
Yes.
A passenger coming in with contraband goods.
Yes, again.
Let me use a very gross example. Someone bringing a firearm into their suitcase. I don't know why they would do that, but it's happened before. Apart from other criminal case responses, the forfeiture would be immediate. And uncustomed, some kind of restricted item, such as a motor vehicle coming without a license or without an import permit, pardon me. There are a number, even things like fireworks are restricted without an import permit. So that 90% of these things will happen, or way over 90%, at the port of entry. There must be, and I do not know, I cannot speak to any of them myself, my lady, my lords, but there must be instances where after investigation, Customs goes through a process, gets a warrant, and goes out and takes possession of goods and says, these things are now going to be seized. We're detaining them for forfeiture. We're seizing them with a view to forfeiture. And the process is gone through and ends up in court. If, of course, the party holding it at the point in time decides to put up resistance, it would, I think in many instances, by the way, Customs, I don't think this is a fact in Jamaica. The Commissioner of Customs, that very wide authority he has, allows him to remit fines or to compromise fines. And they regularly compromise matters so as to avoid the necessity of going to court. And a party will say, okay, I will pay twice instead of 3 times as is permitted by the law. And the Customs Commissioner or his agents will say, fine, we'll accept that. An agreement is done. They have a standard form agreement for it. It is signed by the parties, the money is paid, and possession is kept or taken without any further issue. That is one way in which the problem is handled. Yes, there are many instances of those kinds of agreements, my lady, my lord. The driver, I'm reminded, is often revenue, the collection of revenue, so that the Customs Commissioner will be practical, I suppose, in his deliberations, the cost of going through the court process versus saying, okay, give me 1.5 times the duty and walk away. I think that would be one of the things that he considers. Paragraph. What page? Of what? What page of the electronic file? Page 3. Therefore, again, with your, if there are any further missiles, I
No, thank you.
accept them. Otherwise, I would take my seat with you.
Thank you.
Thank you very much, my lady. I'm sure.
I'm sorry, Miss, is it Guyah or Guyah? Guyah. I thought it might be. A matter that's concerning me is whether under the Code of Conduct for advocates in Jamaica, it is permissible for somebody to appear as an advocate in proceedings in which they have already appeared as a witness.
Is in fact permissible under our Code of Conduct. Perhaps my senior might be able to address this issue better.
Well, I had assumed that you would have sorted this out, but nevertheless, it is a very unusual situation. We don't often come across it. And I am concerned about whether it would be permissible under the Bar Code of Conduct.
I am being advised by my senior, my lady, that an inquiry was made as to whether it would have been appropriate or if it was in fact a problem for me to appear in these proceedings before you, and we were told that it would not have been a problem in this case, my lady. And that is the basis upon which I chose to appear.
Well, on that basis, of course, we are content to hear from you. It would be helpful to have confirmation of that. Thank you.
Very well, my lady.
Thank you. Now, you're dealing with the seizure.
Yes, my lady. I'm in fact dealing with issue C.
In effect, the seizure from you.
That is in fact so, my lady. And the question, yes, my lady, and I'm reminded also that I was not an attorney at the time that the seizure
You were a law
was made.
student, weren't you?
Right. Yes, my lady.
And you were stranded because they came and pinched your car.
That is in fact so, my lady. The respondents contend that if the Suzuki Swift motor car is found to be uncustomed goods, then as a consequence, the motor car must be subject to seizure by customs officers. And to that, the appellant submits that it does not matter whether the goods are uncustomed or not, or in breach of the Customs Act. Once the goods are outside of the customs area, a special warrant must be obtained, and that warrant must be obtained in accordance with Section 203 of the Customs Act from a resident magistrate or a justice of the peace in order for goods to be lawfully detained or seized by customs officers. Your ladyship and your lordships, the Customs Act makes a distinction between the right to seize or detain goods within the custom area or those within the jurisdiction of customs at the ports of entry and those which have left the customs area and are within the island. Customs area, as my learned senior had alluded to, is defined in the Customs Act at tab 2 of the Joint Bundle of Authorities at page 439 of the electronic bundle as a customs area appointed by the minister pursuant to subsection 2.
Sorry, where is that?
It is at page 439 of the electronic bundle.
Section?
Customs area, it is section 2, subsection 2, my lord.
Yes, and where is this provision which says that you can only seize within that area?
It under section 203, my lord. The court says, the law says that if any officer has reasonable cause to suspect that any uncustomed or prohibited goods are harbored, kept, or concealed in any house or other place in the island, the officer may apply to a resident magistrate or a justice of the peace for a special warrant. And in this case, my lord and my lady, we are saying that there was no warrant that was presented and obtained when the vehicle was seized at the material time by the customs officers.
Well, the vehicle wasn't in a house. Was it on? The warrant is directed towards empowering officers to, you can see, A, enter and search, B, open locks, and
Carry away.
and seize and carry away. Now, Was the car, where was the car? In the car park at the law
It
school?
was in a parking lot.
Well, would you need a warrant for that?
Yes, my lord. In fact, Section 203 pointedly says that it must be concealed or kept in any house or other place
You need a
in the
warrant.
island.
You need a warrant to get into somebody's private premises. That's obvious.
Yes, my lord.
But-
And you would need a warrant, if I may so add, my lord, and I must apologize for interjecting, that the Act requires a warrant where the goods are outside of the customs area and within a private dwelling or within any place in the island.
Where does it refer to the customs area?
The customs area, my lord, is not specifically referred to.
Well, it's not referred to at all, is it?
No, it is defined under the Act, my lord, but
Well, I
what
know
we
it
are
is,
saying
but
is that,
what I'm asking is, what is its relevance to 203?
my lord, we are saying that it is important that customs area, we believe, speaks to where the goods are detained in any place, either upon a land, and I will refer to Section 214 of the Act, which says that all goods together with all things liable to forfeiture shall or may be seized or detained in any place, either upon land or water, by any person duly employed for the prevention of smuggling. That would, my lord, we submit, deal with a situation where the goods are within the customs area. And the Parliament, well, the legislators have provided in the Customs Act for Section 203, which says that, okay, if it is not within the customs area or it is not within the customs area and it is in the public domain, then you must go by way of a special warrant. And that is the appellant's contention, my lord.
I see.
So you accept that Section 214 gives power to seize, but you say it's implicitly limited to the customs area,
my lord. And I would comment your ladyship and lordship, the operative words used there, by any person duly employed for the prevention of smuggling. We submit that this section presumes that the goods are still within the limits of a port of call, grounding the jurisdiction of custom officers to detain or seize goods which are attempting to be exported or imported. That is why the law we submit has pointedly chosen to use the word smuggling.
Well, hang on a minute. If you go back to the definition section,
Yes,
section 2, as you say, it provides a definition of the expression customs area
Yes,
on
ma'am.
page 439, and that refers to subsection 2,
Yes, my
which
lord.
we find on 442, which allows the minister to appoint any place to be a customs area,
Yes, ma'am.
to subsection 2C. But presumably, if customs area needs defining, it's because the Act uses the expression somewhere in one or more of its sections.
Yes, ma'am.
Does it? Well, where?
I crave your indulgence, my lord.
Because it certainly doesn't use it in section 203. You say it's implicit.
Yes, my lord, I will crave your indulgence.
You say it's implicit. I understand that. I'm just wondering where the expression customs area does turn up in this statute.
Well, it's certainly in neither 203 or 214.
Section 98, my lords and my lady, deals with private warehouses and custom areas, my lady, my lords.
Right. 98, did you say?
Yes.
Let's have a look at 98. No building or place may be used as a private warehouse or except with the written permission of the Commissioner as a customs area until abolished. in such terms in such sum as may from time to time be required is given by the warehouse keeper. So it's about, in that section, it's about what we would here call bonded warehouses, which is where you can stow things that have yet to be paid their
Yes, my lord, and that is exactly what we are contending. We're saying that section 203 is important because it deals with where goods are in the public domain, they're in a private dwelling, they're within the island of Jamaica, as in this case, my lord, where the goods were in fact in a private parking lot.
So that if, for example, a lorry full of, let's say, whiskey were to be taken out of the port without paying the duty and parked in a car park, the customs officers can't seize it, you say, without a warrant under section 203. Is that right?
That is so, my lord.
Okay, well, maybe.
Section 45, my lord.
45.
Okay, my lord. I'm being corrected that we have found 45 references to customs area in the law.
Yes, well, there may well be quite a lot, but I'm just trying to work out what it's likely to be about. And if it's about bonded warehouses, that's part of the answer.
Yes, my lord, and I would make bold to say, my lord, that there is no evidence before this honourable board that the University of the West Indies, which houses the Norman Manley Law School, was ever made a customs area by virtue of the Act.
No, I expect we can work out that that's unlikely.
We're trying to work out what the meaning of these sections is.
My lord, and my lords and my lady, I would commend to you the case of Commissioner of Customs and Excise against Tan and another, and that is located at tab 7 of the Joint Bundle of Authorities at page Gs 504 to 514 of the electronic bundle. And this clearly explains the point. We humbly believe that it would be beyond the pale to think that the intent of the Act was to give untrammeled, unrestricted, unfettered, and wanton authority to customs officers to enter a private dwelling any time after goods have been cleared, if they have formed the view that more duties could have been collected on a good than that which was determined at the particular time, or that there was some other customs process that was not adhered to. That is why the legislators created a statutory provision in section 203 for an application to be made to a resident magistrate or a justice of the peace, who would then, upon the evidence presented to them, determine whether or not to grant an application for seizure or detention. Furthermore, we submit, my lords and my lady, that the motor car was detained on the grounds of investigation by way of a notice of detention under section 214 of the Customs Act. And we submit that that is in and of itself an abuse of power of the agents of the respondents. The language of section 214 of the Customs Act is clear and patent. It says that goods seized or detained must be liable to forfeiture. And the authorities support the view that the status of being actually liable to forfeiture must exist prior to the goods actually being seized or detained by the customs officer. Therefore, it is our humble submission that there had to have existed a breach of the Customs Act in order for the goods to be seized or detained.
It was detained for the purpose of investigation, is what the form says.
Yes,
Are you
ma'am.
saying there's no power to detain for the purpose of investigation?
I did not hear you, my lord.
Are you saying there's no power to detain for the purpose of investigation, which is what was...
I am saying that
Because
that is...
in the EastEnders case, we certainly thought that in this country there was a common law power to detain for the purpose...
No, my lord, I would say that the EastEnders case deals with a situation where there is the common law power to detain goods for inspection to determine the duty payable, or whether there is some custom, whether the goods should be forfeited overall. The court in that case opined that that power was restricted and it was temporary in nature and would not apply, and it is completely different
But
from
this is
detention.
I understand the car has been given back now. Yes? The car has been given back now. So,
No, my lord, It is still on the customs ports. I believe it's a relic of what it was.
well, the Court
It
of
is still
Appeal,
detained.
I thought, said that it had been given back.
No,
It's
my
not.
lord. No, my lord. It is still rested in the same place from whence it was
I mean,
unlawfully taken.
can I begin? What the relevance at this point is what? That you want the car back and you want damages? I mean, what's the relevance at this point about whether...
Well, my lord, what we're asking the court to do is to declare that there was no legal authority under which the customs officers had at the time when they seized the motor vehicle, that being the one Suzuki Swift motor car. And that any finding that it was seized lawfully, my lord, would be a serious problem, my lord.
Sorry, but what remedy are you... I mean, it's one thing to say it's unlawful, but if...
It's just a declaration, my lord, that we are seeking.
I mean, I was looking at page 266, paragraph 18, where the Court of Appeal said it appears that the vehicle was returned to Miss Carter and the criminal case against Miss Guyah was dismissed. So I'd rather assume that the car had gone back to Miss Carter.
No, my lord. No, my lord. There is no evidence of that, my lord.
Oh, so we don't know where the car is?
Yes, my lord. It is in fact on Shalimar Avenue in Kingston, Jamaica, at the Revenue Protection Division, where it is being kept.
Well, I'm not sure that we can listen to evidence in the case.
I understand that, my lady.
Nor do we know what Shalimar Avenue is.
That is in fact...
That's not going to help us very much.
So anyway, you say that the last paragraph, paragraph 18 of the Court of Appeal is wrong, that it hasn't been returned.
It is in fact wrong, my lord.
One of the cases that we discussed in EastEnders was an old case called Irving and Wilson, which was about customs officers stopping a cart on a public road because it contained, they stopped it, it contained goods that required a permit, and without the permit the goods were liable to forfeiture, and the carrier didn't have the permit on him but told the customs officers that the goods were part of a larger consignment and a permit for the entire consignment was with the remainder, which were on the road some miles behind. And the court held that it was lawful to detain the cart until the other carts arrived and the permit was produced, because they had reasonable grounds for suspicion that the goods might be liable to forfeiture. So that was a common law power. Now that was I suppose, would you distinguish that on the basis that that was a public place, or what?
Well, I would say, my lord, that in response, as Section 204 of our Act, which is different from the Act that was applied in that case,
Well, that wasn't applying an Act at all. It was simply a common law power.
But as I understand it, my lord, the Supreme Court upheld the reasoning of the lower court in its judgment that the right to seize or detain property is dependent on the property being actually liable to forfeiture. And they opined this was based not on the beliefs or assumptions of the customs officers, however reasonable they were at the time, but on the objectively ascertained facts that it could be seized. The court reasoned that the words liable to forfeiture used in the Act were deliberate, clear, and intentional, and therefore cannot be presumed to detain goods without any grounds for suspicion, but purely with a view to further inquiry, in the blind hope that something may later turn up on that further inquiry to justify that detention. My lord, what we're saying in this case is that the motor car was within the public domain, and rights had accrued to a party other than customs. So customs officers would not be at liberty to come and take up the goods and seize it without having presented a warrant to the third party whose rights have accrued, my lord. And the case of EastEnders, my lord, the appeal dealt with a situation where the goods were being held at a customs warehouse. my lord, as opposed to being in the public. I hope that has answered your
Yes.
challenges, my lord. My lord, we also assert that the undisputed evidence of the respondent's document in its notice of detention at page 26 of the electronic bundle, grounds being for investigation amounts to an infringement of a citizen's constitutional right to property and trespass, warranting a court to assess whether the seizure or detention was lawful. We ask this honourable board to consider that a finding that the seizure was lawful would mean that customs officers of their own volition and without the need to satisfy any one of their grounds for so believing could determine that the goods imported and delivered from customs charge after payment of the duty demanded and compliance with the applicable customs procedures are liable to forfeiture at any time, irrespective of the current owner, and could be seized or detained at will. We make bold to say, my lord, that I do not believe that was the intention of Parliament. The respondents also contend that the appellant is not entitled to a declaration that the seizure is unlawful, as he does not have the locus standi to seek such a remedy, as he is not the owner. My lords, we note that this issue of locus standi was not an agreed issue for determination before the board, but only arose as a consequence of the respondent's written case. However, the appellant will say that a finding as to whether the seizure of the motor vehicle was lawful is a declaration of fact and law, and whether declaratory as to rights or as to law does not confer any other rights on the appellant and cannot therefore, we submit, be shut out from the board's consideration. In the circumstances, my lady and my lords, we ask this honourable board to find that the learned justices of the Court of Appeal erred in their interpretation of Section 214 of the Customs Act as giving the customs officers the power to detain goods in the public domain without the need for a warrant, and further misdirected themselves in finding that if the goods were found to be uncustomed, that the seizure was proper. We ask this board to find that customs officers acted unlawfully in seizing the said vehicle without the proper judicial authority and without any reasonable grounds for so doing, unless I can be of further. And it is an abuse of their power. Unless I can be of further assistance. Yes.
Sorry, yes. Paragraph 82 of the Court of Appeal's judgment, they said that Mr. Guyah would have had no standing to claim an order that the vehicle had been unlawfully seized because he hadn't been shown to be the owner. What do you say about that?
Well, what we would say on that issue, my lord, is that the appellant has maintained that he is the equitable owner of the motor vehicle. And this assertion...
Well, I know he said that was said by his advocate today, but as far as the evidence goes, the registered owner is Miss Carter, and there's no reason to think that she isn't the beneficial owner.
Well, my lord, we have provided the receipts, my lord, of payment of the custom duties and taxes in full, paid by the commission, by the appellant, via his credit card, my lord, and that is in your bundle, my lord, as to support the fact that he is the beneficial owner, whilst not being the legal owner on paper, my lord.
I see. So you say the Court of Appeal were wrong in that paragraph on the facts.
Yes, my lord.
Right, thank you.
But you also say that he's not actually claiming any remedy
No, my
in
lord.
relation to the car. All he's claiming is a declaration as to what the correct position in fact and law is, and for that he doesn't necessarily have to show that he is the owner.
Yes, my lord.
That was your first answer to
Yes, my
that
lord.
question. But your second is, and in any event there is evidence in the bundle
Yes,
to
my
suggest
lord.
that he is the beneficial owner.
Yes,
That's your second answer, isn't it?
Yes, my lord.
Yes. Well, thank you very much indeed, Ms. Guyah. Thank
Yes,
you.
I'm so grateful to the honourable board. I will leave to my senior who will address you on issue D.
Yes, well, you're out of time. You've now had the amount of time for which you indented, plus the quarter of an hour that we adjourned for in order to try and get the materials that we thought we needed. So can you be extremely quick?
I think I can.
And of course, it will all come off your reply time.
Yes, I think I can be. A moment, please.
You're basically saying that the courts below were very unfair to be so critical of your client.
Indeed.
and he should not only win but get his costs.
The issue with respect, my lady, is not so much about costs. If you'll allow me to just open a document here.
But unless it's about costs, it's not really a legal issue.
With respect, my lady,
You
I
can't
won't
appeal,
bore you with the
you
details.
cannot, forgive me, you cannot appeal against things that are said in a judgment unless they are relevant to an issue under appeal.
We sought a specific order from the Court of Appeal for a declaration that those things were irrelevant. They ought not to have been said. One of the cases that Justice Brooks, in fact, relied on spoke about and it's rather interesting because the case seems to make the very point that these things shouldn't be said. And this was paragraph 93 of the judgment of the Court of Appeal. This is page 302 of the electronic bundle. It's the case of Society Generale London branch against Guy, is it Gaze? Justice of Appeal Brooks quoted Lord Sumption, who in a dissenting judgment stated at paragraph 140 that it is no part of the purpose of the law to reflect moral indignation about SG's conduct, even assuming that SG's mistake calls for moral indignation, which I doubt. Of course, it's irrelevant whether or not His Lordship was right about that aspect of it. But, a moment, please. The issue as framed was whether the Court of Appeal erred in finding that it may have been reasonable for the Supreme Court to have made conclusions concerning the conduct, character, and integrity of the appellant. And it is clear, my lady and my lords, that that was the foundation for Justice Pusey's refusal to grant the appellant his costs, even though he was ruling in his favor. We don't deny his jurisdiction to make the order that he made. We think that the order was wrong in circumstances where our own civil procedure code rules, which he was referred to, states explicitly that the general rule is that the successful party ought to have his costs. And I further go on to say that if there was any moral indignation which ought to have affected the costs, it would have been the kind of situation where the court apportioned the costs. But to say no costs at all, we think in these circumstances, was unfair. We do not think that the issue requires, I don't intend to spend much time on this because I think that all written submissions properly encapsulates and captures the points we are making. And we think it is made clear that the Supreme Court and the Court of Appeal, both, their traversal of this issue was unwarranted and unnecessary. And I go on to say that courts exist for the determination of disputes, and the instances are rare when it is necessary for courts to make moral judgments. Those kinds of instances are of the kind such as murder most foul, high treason, genocide, and heinous offenses which trouble not just the judiciary and the victims and parties, but also affects public consciousness as well. If indeed Mr. Guyah can be said to have profited from the knowledge of his avocation, a point which Justice Pusey relied on, we submit that such a conclusion does not place him in a category of litigant to receive this kind of judicial condemnation and vilification of the permanence which judgments of Her Majesty's courts carry. I respectfully submit and refer your lordships to the words of Aristotle, which we cited in our written case. The law is reason set free from passion. That passion, I submit respectfully, was evidenced in paragraphs 27, 34, and 38 of the judgment of Justice Pusey, when he compendiously described Mr. Guyah as a man without ruth, a very uncommon word, a person acting contrary to the rules of his employer, notwithstanding, of course, that no evidence of that was before him, and attempting to benefit, to obtain financial gain from knowledge which came to him because of his position. It is noteworthy that these positions, my lady, my lords, were neither advanced nor canvassed by the respondent before Justice Pusey, and that before the Court of Appeal, the respondent, through its counsel, conceded that the comments were, the word used was unfortunate and not based on evidence. Why, therefore, these conclusions or comments were permanently inserted into both judgments is unfathomable to the appellant. The appellant, who is in this courtroom, was 31. I say this with, with some fear and trepidation, my Lord Hughes, was 31 years old at the time that Justice Pusey handed down his judgment. A judgment which has condemned him for the rest of what would ordinarily be expected to be a long and useful life, on allegations which, even if they have not resulted, even if they're true, have not resulted in a criminal trial, much more a conviction. We therefore respectfully submit to the board that in relation to the orders made by Justice Pusey, and this is a summation of what it is that we are asking for, my lady, my lords, that orders 1 and 2 be restored. Those are the orders made by Justice Pusey which declared the goods to be, the car to be not legally classifiable as uncustomed goods at the relevant time. Order 2 was an order which declared that the customs officers had no authority to seize the vehicle at the time they did. We also asked that Order 3 of Justice Pusey be set aside, and in its place an order declaring that the seizure of the Suzuki Swift motor car was an abuse of the powers of customs, which we think follows because that power did not exist at all. And that furthermore, an order be granted in the terms sought in Order Roman 2 in the Notice of Appeal dated 30th of March 2015, and that the costs of and occasioned by the fixed date claim form and the appeal before the Court of Appeal be granted to the appellant. And finally, my lady, my lords, in keeping with what I believe is your board's rules, we will await your guidance on submissions as to costs before the board.
Yes, that's normally what happens. Unless everybody's agreed that costs should follow the event, we give our advice to Her Majesty and await and a deadline for submissions on.
And in that regard, I once again, and although regrettably I do not have it in front of me, but I'm sure that you may be able to reach out and touch it. Our own CPR, and I cannot tell you the rule, it's in part 64, that much I know, explicitly states that the general rules that costs follow the event. It then goes on to make the point very clearly, very lucidly, that the court has an absolutely overarching power to adjust costs based on the party's behavior before, during, and after the event or trial. And that at the end of the day, the matter of cost is squarely in the court's hands.
Yes.
That is all I can advance at this point, my lords.
Thank you very much indeed, Captain Bessett. Thank you. Madam Attorney.
May it please you, my lady, may it please you, my lords. Your ladyship and your lordships have made a number of comments during the presentation of counsel for the appellant, which indicate just how troubling this case is.
Can I just be clear? I'm sorry to interrupt. Are you appearing for the Commissioner as well as for the Minister?
We appear for both respondents.
So you appear as Attorney General,
as Attorney
also
General
for the Commission.
And also for the Commissioner. Appearing with me is Ms. Althea Jarrett, the Director of State Proceedings in the Attorney General's chambers. And Ms. Jarrett, in fact, had conduct of the matter in the courts below, both at first instance and on appeal. My lady, I'd like to begin my introductory remarks with a matter you raised as to the propriety of counsel who is a witness in this matter appearing. And I note that counsel presented on the issue of the seizure and on the evidence the car was seized from her. It was said by senior counsel that it was seized at the Norman Mandel Law School, but that is not, in fact, in keeping with the evidence, because the evidence is that they were taken elsewhere to a friend's house. And you can see that in the paragraph of Ms. Guyah. But I wanted to know with whom counsel had conferred as to the propriety or as to whether it was advisable to have young counsel who is a witness in the matter also appear on an issue that she is so intimately involved in. And in particular, during her submissions, when she attempted to, by way of submission, give some evidence as to where the vehicle currently is. And I say that because there is, in fact, Canon 4J of the canons of the profession in Jamaica, which speaks to the duty of counsel to maintain the dignity of the courts and the integrity of the administration of justice. And that canon speaks to an attorney shall endeavor always to maintain his position as an advocate, and shall not either in the argument to the court or any address to the jury assert his personal belief in his client's innocence or in the justice of his cause or his personal knowledge as to any fact involved in the matter under investigation. And it is most unfortunate that very young counsel was put in a position where, in arguing that agreed issue, she attempted to breach this canon. Whatever action will be taken is a matter to be determined, but I believe it is most unfortunate. But it appears, my lords, that there are questions as to what is right and wrong as one looks on the case and on the conduct of the case. I think the records show in the presentation an inconsistent approach by the appellant through the various stages, from the hearing of first instance to the appeal, and now here in submissions before your lordships. We see attempts to resile from the evidence through submissions, or even attempts to add to the evidence through submissions. It is true that the only evidence before the board, as was before the courts below, was the affidavit of the appellant and that of his two sisters, in addition to matters exhibited. Counsel for the appellant has indicated that the case is of dire importance for him and his future, and so it is for the government of Jamaica, because the appellant stood in a special place in relation to the first respondent, and some of the powers granted to the first respondent under the Customs Act were exercised by the appellant. And your lordships have heard the attempt to resile from the starting point where the goods were treated as seized. That's the starting point. It was accepted by the courts below that, on the appellant's own words, he seized the goods. Fully appreciate and understand the wider issue that your lordships have raised as to the power to have acted. But regardless of that question, the case did proceed on that basis. And to the extent that the courts below accepted his assertion and found, as a matter of fact, that the goods were seized, and then assessed the case thereafter as to whether the seized goods, they were seized, forfeited, and deemed condemned.
But this was under the authority of your client, the commissioner.
Yes.
Yes?
Yes.
So why are you not able to tell us, or are you able to tell us what provision it was done under?
Well, you know, my lord, there are many curious things about the case. So it proceeded as if we moved to 215. So the issues...
No, I mean, it doesn't matter the fact.
Right.
You are asserting that there was this forfeiture
Yes.
Done under the order of your client, the commissioner.
Yes.
So I assume your client has some record of this having been done and would be able to tell us what power it was done under.
It proceeded as if it were under 210, my lord, based on the evidence of the appellant, who was exercising
Why
powers.
can't your client tell us?
My lord, the records show that we did attempt to put in the affidavit, but unfortunately, the records show that the instructions did not come in time.
Not trying to put you in the position of being required to give evidence about it.
Exactly, my lords. But let us be clear that the records disclose that the appellants did not comply with the rules in time, but did make an application at a later stage to have the evidence put in.
I think it's
And
the
that
respondents,
application.
isn't it?
The respondents.
It's
yes,
you.
ma'am. Yes, the respondents.
It's you.
We.
You didn't.
But you know, there is a little. I'm trying to find the right word. So we're seeking to get the evidence from the first respondent, who is a commissioner of customs, and on the evidence presented by the appellant, he played such an integral role. He asserts himself as being the expert in customs law. When the matter came up, it was to him that it was referred for his review and his recommendation. And what proceeded thereafter, presumably, proceeded because of how he reviewed the matter and the recommendations he made to the commissioner. It is indeed an awkward place for us to be in, but it is what it is in terms of what it shows up. So, my lord, in terms of the issues agreed.
Well, we've reached 1 o'clock.
Yes.
That seems an appropriate point at which to pause, and then you can turn to the issues.
And I will tell you how we will.
So we'll look forward to hearing from you further at 2 o'clock. The board will now adjourn.